208.16, with regard to a discontinued action in New York City Civil Court, the stipulation or statement of discontinuance shall be filed by the attorney for the plaintiff with the clerk. 208.17, in New York City Civil Court, where all parties appear by counsel. Any party may move to strike the action from the trial calendar or prevent it from being placed on the trial calendar within 20 days after service of the notice of trial. 208.34, when a judge assigned to a multiple part court in the New York City Civil Court is unavailable or unable to act for more than 2 successive days, the administrative judge, having direct supervisory authority over the court, shall make whatever arrangements are necessary to accommodate the proceedings assigned to that judge. 208.27, upon the trial of an action in New York City Civil Court, copies marked pleadings, copies of any statutory provisions relied on, and a copy of the bill of particulars, if any, shall be submitted by whichever party filed the notice of trial. So, in New York City Civil Courts, whoever files the notice of trial shall submit copies marked pleadings, copies of any statutory provisions relied on, and any copies of bill of particulars. 208.29, a hearing to determine whether process was validly and timely served upon a party is called a traverse hearing. So if somebody doesn't feel that they were served properly or it's valid, you can have a traverse hearing. 208.41, small claims procedures in New York City Civil Court. A small claims action shall be instituted by the plaintiff or someone on his behalf paying a filing fee. Also, the plaintiff shall supply information about himself, the defendant or the defendants, and the amount and the nature of the claim to the clerk. And within 5 days after the action is recorded, the clerk shall send by ordinary first-class mail and certified mail, return receipt requested, addressed to one or more of the addresses supplied, and shall be deemed necessary, a signed notice bearing the seal of the court, which shall be substantially in the form provided for in Rule 208.41. Also, in small claims procedures, it's the clerk that shall reduce the information to a writing. So pretty much in small claims procedures in New York City Civil Court, it's the plaintiff who institutes the small claims action, or it could be on behalf of somebody paying a filing fee, and the plaintiff is the one who has to supply the information about himself and the defendant and the amount and the nature of the claim, and he has to supply that to the clerk, and then within 5 days of recording it, the clerk has to send by first-class mail or certified mail, return receipt requested, to the addresses supplied by the plaintiff, and it's deemed necessary a signed notice bearing the seal of the court, which shall be substantially in the form provided in Rule 208.41. 208.43, housing parts in New York City. Summonses. The summons shall state the county division and location of the court in which the action is brought, as well as the names of the parties and the addresses of the premises, and shall comply with the provisions of NYCCCA applicable to summonses. Form of summonses. The summons in cases involving an action in housing part for the recovery of civil penalties shall be in such form as may be promulgated by the chief administrator. Where a hazardous or non-hazardous violation is alleged and the summons is personally delivered to the landlord or its registered agent within the city of New York, the defendant shall appear and answer within 10 days after service. Where a summons for a hazardous or non-hazardous violation is delivered by mail or by any other method, The defendant shall appear and answer within 20 days after proof of service is filed with the clerk of the housing part. Where the summons for a hazardous or non-hazardous violation is personally delivered to the landlord or a registered agent, the affidavit of service shall be filed with the clerk of the housing part within 5 days after personal delivery. Where the summons for a hazardous or non-hazardous violation is served by any other method, the affidavit of service shall be filed with the clerk of the housing part no later than 10 days from the date the summons is posted and mailed where such mailing is required. Where the summons for a hazardous or non-hazardous violation is served outside the city of New York, the affidavit of service shall be filed with the clerk of the housing part within 10 days after service. A penalty action for an immediate hazardous violation shall be commenced by order to show cause, returnable within 5 days or within a lesser time period in the discretion of the court. So 208.43 Housing Part, New York City, the summons, it shall state the county division and the location of the court, the names of the parties, the addresses of the premises, and it shall comply with the NYCCCA. And the form of the summons is promulgated by the chief administrator. And when they talk about service and filing of the service, if it's personally delivered to the landlord, he has to answer within 10 days. If he's not personally delivered, he has to answer within 20 days. If he's personally delivered, he has to answer within 10 days. And then the affidavit of service has to be filed within 5 days after it's personally delivered. But if he's not personally served, and if he's served by mail or any other service, he has to answer within 20 days. And then the proof of service has to be filed no later than 10 days from the date the summons is posted and mailed. And if it's served outside New York City, the affidavit of service shall be filed within 10 days after service. And penalty actions for immediately hazardous violations commenced by order to show cause and returnable within 5 days or less. So, personally delivered in New York City, answer within 10 days of service, affidavit of service filed within 5 days. If it's mailed or served any other way, answer within 20 days, affidavit of service filed no later than 10 days after the date the summons is posted. And if served outside New York City, affidavit of service filed within 10 days after service, and the penalty action for immediate hazardous violation commences by order to show cause, and the returnable date is 5 days or less. 208.41. Neil commences a small claims action against Dorothy in New York City Civil Court, Kings County. Both Neil and Dorothy appear in court on the hearing date. Before walking into the courtroom, Dorothy pays $3 and files a counterclaim against Neil for $1,600. If Neil does not request an adjournment, the judge may proceed forthwith to hear the entire case, including Dorothy's counterclaim on the merits. 208.8. A motion to change the venue from one division to another shall be heard in the county division where the action was instituted.